Welcome to our noon webinar. We are so happy to have Jennifer Gimler Brady from Potter Anderson and Corroon with us today. She's going to give us an overview of the list of excluded individuals and entities, the LEIE. Jennifer?
Good afternoon, everyone, and thanks to my friends at First Healthcare Compliance for having me speak this afternoon. I'm going to be speaking about the list of excluded individuals and entities, and I thought I would start with a little background about the LEIE, or the list of excluded individuals. The list started in 1977 when Congress mandated the exclusion of healthcare providers who were convicted of program-related crimes against the Medicare and Medicaid programs. Later, a few years later, the Office of Inspector General was authorized to impose CMPs, or civil money penalties, other assessments, and program exclusions against individuals who submitted false claims or fraudulent or other types of improper reimbursement claims to the Medicare and Medicaid programs. The Health Insurance Portability and Accountability Act of 1995 and also the Balanced Budget Act of 1997 further expanded the scope of exclusion authority beyond Medicare and Medicaid programs to all federal health care programs, or FHCPs. That would include things like TRICARE, veterans programs, etc. So really any type of health care program that is administered or overseen by the federal government is now falls within the scope of the list of excluded individuals. The Balanced Budget Act also gave the government new civil money penalty authority against healthcare providers who enter into contracts with or otherwise employ an excluded individual to provide services that may be reimbursed under a federal health care program. So the point of the list, if a provider engaged in some type of misconduct related to a federal health care program, the government has the authority to put them on a list of excluded providers, and eventually the law provided that people who employ or contract with an excluded provider could likewise be sanctioned under the LEIE authority. The Affordable Care Act has further expanded the scope of the LEIE by giving the Office of Inspector General the authority to waive certain listings of excluded individuals, but also added a provision that subjects an excluded individual to liability if he orders or prescribes an item or service while he is on the exclusion list, and he knows that there will be a claim submitted to a federal health care program seeking reimbursement for that item or service. So it's further expanding the liability of individuals who are included on the exclusion list. So what does it mean if you are included on the exclusion list? Well, the effect of an exclusion is that no federal health care program payment can be made for any items or services that are either provided by an excluded person or are provided at the direction or on the prescriptive authority of an excluded person. That means that anyone who is on the list essentially cannot provide, either directly or indirectly, any service that might be subject to a reimbursement claim that traces back to a federal health care program. The exclusion and payment prohibition continues, it stays with the person who is on the list regardless of their position in the healthcare profession. Meaning that the exclusion travels with them. For if you have someone, say, who is both a pharmacist who happens to be going to med school, and during the term of their exclusion, they become a physician, the exclusion, if it originated while they were a pharmacist, follows them into their new employment as a physician during the period of exclusion. And that is how individuals are included on the list. When they have been added to the LEIE, it is for a period of time. So it doesn't really matter what role you play in the healthcare profession while you are on the excluded list. Any services that you provide cannot be reimbursed by a federal healthcare program. An excluded provider can refer patients to another provider who is a non-excluded provider, as long as the provider who is on the exclusion list doesn't have anything to do with the services that are provided to the patient, meaning that the excluded provider can't consult, can't furnish services, and can't participate in any of the billings for services that are provided to a patient that the excluded provider refers. And it doesn't matter whether the non-excluded provider handles all of the patient care and independently bills. The excluded provider cannot participate in the provision of care or in the billings in any fashion while they're on the exclusion list. The prohibition on federal health care program payment doesn't just pertain to direct patient care, however. It also extends to excluded individuals who work for or under arrangement with a hospital, a nursing home, a home health care agency, a hospice agency, or a managed care entity, regardless of whether there is separate billing or a bundled payment. The issue is whether the excluded person is providing any of the services that are being requested, for which reimbursement is being requested. So even if it's a bundled payment, a set payment, regardless of the scope and nature of the services, if an excluded provider is providing those services, it may not be submitted for reimbursement to a federal health care program. That also extends to roles within a healthcare organization. An excluded individual cannot serve in an executive or leadership role for a healthcare provider that provides services that are payable by a federal healthcare program, meaning that an excluded person cannot serve as the CEO or the chief financial officer, general counsel, the director of health information management, the director of human resources, or practice manager. Anybody who's really in a position to control the operations or direct the operations of a healthcare provider may not be an excluded individual if that provider is seeking reimbursement for services through a federal healthcare program. So if an excluded person submits a claim for reimbursement to a healthcare program while they are on the exclusion list, the penalties can be pretty severe. They can be subjected to a civil money penalty of $10,000 per service or per item, plus a 3 times that amount of the claim penalty. These items can be very significant because anybody who's familiar with healthcare billing knows that you can have a single claim for service could have multiple subparts. And the authority of the OIG is that each of those individual subparts can be fined at 3 times the amount of that claim associated with that particular subpart. So you can imagine that the monetary penalties for wrongful claims can be very substantial, and these are intended to be penalties that would dissuade somebody from engaging in this type of conduct. So they can add up very quickly. You can also be subject to a denial of reinstatement. As I mentioned earlier, when you're listed on the LEIE, it's for a set period of time, and then you can be reinstated. But if you engage in wrongful conduct while you're on the list, that is most likely going to result in you being denied reinstatement. Plus, the additional hammer that has developed over time is that you can be subjected to criminal prosecutions as well as separate civil actions beyond the civil money penalties that can be imposed. So the sanctions can be rather serious. I should note that exclusion does not necessarily mean that an excluded provider cannot have an ownership interest in a provider that participates in a federal health care program. But it is risky. For example, if you have a physician partnership and one of the partner physicians is a sanctioned provider, in addition to making sure that that physician does not provide services either directly or indirectly that are reimbursed through a federal health care program, the partnership needs to be mindful of the ownership interest of that particular partner, because it could impugn the entire partnership if that ownership is greater than 5%. An ownership level of greater than 5% is going to get on the government's radar screen potentially. So if an excluded person owns a greater interest than that. As I also mentioned earlier, the Balanced Budget Act expanded the authority to sanction with CMPs providers who employ or enter into contracts with excluded persons. And so if a healthcare provider does engage an excluded individual to provide services that ultimately will be the subject of a claim for reimbursement to a federal healthcare program, and that person either directly or indirectly provides those services, the provider can be sanctioned with a civil money penalty, again, of up to $10,000 per item of service, plus the 3 times the amount claimed penalty and program exclusion. And that's more problematic for a multi-provider entity if the entire provider group is put on the sanction list. That means all of the healthcare providers who provide services under that entity are likewise tainted with that exclusion. So it's a pretty serious penalty if the provider entity gets placed on the healthcare exclusion list. And it doesn't matter whether or not the excluded person actually receives payment from the provider for his or her services. The sanctioning authority is designed to dissuade a provider entity from employing anybody on the sanction list to provide services that might be reimbursed through a healthcare provider, through a federal healthcare program. It doesn't matter whether the excluded person actually receives payment for his or her services. So the bottom line is excluded persons should not provide any services that might be payable by a federal healthcare program, regardless of the relationship with the provider. So what is the LEIE? We've talked about how you can get on the list and what some of the sanctioning authority is, but what is the actual list and how does it work? The Office of Inspector General maintains the LEIE on its website, and it can be accessed through oig.hhs.gov/exclusions. And the LEIE comes in 2 forms. It can be accessible through a searchable online database, or someone who needs to be aware of LEIE status can download data files and search at their leisure by having access to these data files whenever they would like. We're going to talk about some limitations with that shortly, though. The exclusions page on the OIG website does contain some helpful quick tips on how to use the exclusion list and how to search it. Some frequently asked questions about the exclusions program, information for providers as to how to apply for reinstatement, and other general information about the program exclusion. It's a fairly informative website. If you are in need of searching the database, the online version contains the name of the individual at the time of exclusion, the provider type, the statutory basis for exclusion. It will indicate what the nature of the offense was that led to the individual being excluded. the individual's address, date of birth, and the state where they resided at the time of the exclusion, or where the provider entity was doing business at the time of the exclusion, and the ability to verify results using social security numbers or employer identification numbers. The website does not yet have the ability to confirm with national provider identification numbers, but that is coming. And I should note that the name of the individual is an important factor because names can change through marriage, through legal name changes. So it's really important that you search the database as thoroughly as possible using the best information that you have available to you. The downloadable data file does not contain social security numbers or EINs, so you don't have that extra verification point if you use the downloadable files. The downloadable file also requires you to periodically update your downloads. The LEIE is updated monthly, so if you download the data files today, within a month they're going to be stale, so you need to make sure that you update your downloads periodically as well. When checking the LEIE, you should make sure that you keep a record of the initial name search that you performed. Again, going to my back to my point about making sure you use the best available information to conduct your searches. You want to confirm the name that you actually searched in the case there's any question going forward about whether you searched the correct name or whether you have multiple providers like Dr. John Smith that are under the same name. You want to show that you were able to try to refine your search to give you the best possible results based on the information that you have. You can use a third party to perform your LEIE screening, and I know that First Healthcare Compliance performs that service for its clients, but I also should mention that the providers retain the ultimate responsibility for the results of those searches and maintaining timely information. To avoid potential CMP liability, providers are going to need to and want to check the LEIE prior to employing or contracting with persons, with any folks, and periodically check the LEIE to determine the exclusion status of current employees or contractors. Bear in mind that there is some lag time occasionally, so you may employ a physician, for example, today and conduct your LEIE search, and that physician comes back with no hits on the database, but 6 weeks from now, a matter that related to the physician's former employment gets resolved, and suddenly the physician is on that LEIE exclusion list. And so it's really important that you not just limit your search to initial employment, but periodically update your searches. A best practice recommendation is monthly screening to minimize potential overpayments and CMP liability because of that potential lag time, and because sometimes you have employees who have multiple employments and may work for different employers, and a sanction may be imposed relating to another employment, and you as the new employer or current employer may not know about it. So it's really important that you update your searches at least monthly. Providers, in terms of trying to assess their risk spots, should look at each job category or contract relationship that they have and determine whether the item or service that's being provided pursuant to that specific job category or under that contractual relationship is either directly or indirectly payable by a federal health care program. If you can trace a service back to a claim for reimbursement, your best bet is to screen all individuals who perform either under the contractual relationship or in that job category. So anything that might ultimately tie back to a reimbursement claim to a federal health care program, anyone associated with that service or item should be screened periodically. Obviously, the greatest risk is to those people who provide items or services that are integral to patient care. That is the most direct connection to a federal health care reimbursement claim. Providers who are subject to exclusion can be granted waivers in very limited circumstances. For example, if you're talking about the sole community physician, the only physician in the community who provides that particular service, or the only provider who provides an essential service within a community, can get a waiver, but the individual who's excluded cannot request the waiver. The waiver request has to come from an administrator of a federal or state healthcare program in order to allow a waiver to go forward, because that administrator has to justify why there should be a waiver in that particular case and why those are essential services that need to be provided through the excluded provider. And as I mentioned, reinstatement is not automatic once the exclusion period ends. You need, if you're an excluded provider, you need to request permission to participate again in a federal health care program, and you have to receive authorized notice from the OIG that your request for reinstatement has been granted. Until that time, even if your exclusion period has been served, if you don't have reinstatement authority, you are still claims for services provided by you are still tainted. There is a process for self-disclosure under many of the federal fraud and abuse statutes. There is encouragement for providers identifying their own problems and concerns and coming forward through a self-disclosure protocol. And the LEIE is no exception. There is a self-disclosure protocol that encourages providers to come forward and disclose perhaps an improper relationship or the employment of a excluded individual, and to resolve the potential CMP liability up front. Now, the benefits of doing that are that you show the government that you do have a robust compliance program. You found your own problem and you came forward accordingly, and it could help you avoid a corporate integrity agreement, or it helps mitigate the potential penalties, and you could potentially avoid a very expensive and invasive and frankly disruptive investigation when you come forward with your own claim or your own disclosure of potential misconduct. The downside is there are no guarantees. Simply because you come forward doesn't mean that the government is waiving its ability to sanction you, or is waiving its ability to sanction you at the highest levels. But in general, the government will look on favorably on someone who comes forward and acknowledges their own wrongdoing, and also offers to reimburse the government for any wrongful reimbursement claims for which the provider was paid. I've included in the PowerPoint presentation a link to accessing the self-disclosure protocol, if anyone's interested in that. Other sources of LEIE guidance. The Office of Inspector General has updated its special advisory bulletin on the effects of exclusion. The original bulletin came out in 1999. It was updated in May of last year, and it gives a lot of helpful guidance on the exclusion program and providers' obligations to periodically screen to make sure that their providers are not excluded. There are also video podcasts on the OIG website. There's a process for requesting an advisory opinion from the OIG if there's a particular circumstance that is questionable and that is arguable either way. Providers will often go to the OIG to request guidance on their specific situation. The advisory opinions are limited to the specific facts that are presented to them in the advisory opinion request, so they don't necessarily generally apply to providers across the board, but they are helpful to give you some guidance as to how the OIG might view a particular circumstance. You can also get guidance in special fraud alerts that are published periodically, and of course the folks at First Healthcare Compliance can give you additional guidance on the LEIE and in screening tools that are available. So that concludes my presentation. Thank you all for your time.
Thank you, Jennifer. Thank you for joining us today. And this is a very helpful information on the LEIE. Her information is here on the screen, and you can also contact us at First Healthcare Compliance. Thank you.